And now we are down to People of the State of Michigan versus David Thompson, file 24-3559FH.
Yep. David and Houghton, I'm appearing on behalf of the AG's office.
Mr. Thompson is representing himself, and I'm advisory counsel in this matter, but I can advise the court there is no other agreement.
All right, so Mr. Thompson is now here, making his way to the defense table.
Yes. Oh, sorry.
Just call me David, Your Honor.
All right, well, all right, so we are currently set, so you can have a seat.
Here we have the fast-paced hook. The court sets a firm deadline for plea agreements, emphasizing that last-minute negotiations must be completed. For viewers, this shows how courts manage logistics, fairness, and efficiency simultaneously. It's more than a procedural step. Jurors, staff, and law enforcement must all coordinate, and the court ensures nothing derails the process. Thompson's self-representation adds tension, because any delay now directly impacts the courtroom schedule. Take note, deadlines in court are not arbitrary. They protect due process and prevent chaos, especially in complex cases like this one.
Just as you may have heard me say earlier, don't take any thought. I have nothing to know about the case. I'm just going to tell you that, as I do to anyone here for a final pretrial conference. Today is the last date in which to enter a plea pursuant to any pretrial agreement. Any plea from here on out must be done by entering a plea as charged. The reason I do that isn't to punish the defendant, isn't to punish anybody or encourage a case to go in any one direction. It's just to encourage you all to exhaust any negotiating that you've got to do, because everybody's got to issue subpoenas. Subpoenas have to be served by police officers or process servers. My staff has to issue jury notices on February 19th. So that way we have the one day to do the other file and the second day to do this case. So I'll issue jury letters to 4 sets. 4 panels, 2 for each day. So Mr. Thompson, that means that even though your notices say that our trial was to begin on the 18th, we're going to begin it on the 19th. We do jury selection in the morning. I need to remind you that.
This is where the court ensures Thompson fully understands self-representation implications. The judge explains that assistance does not equal full representation. Cross-examinations and legal strategy remain his responsibility. This moment is crucial because it highlights the balance between constitutional rights and practical legal realities. For the audience, representing yourself is a right, but it carries immense responsibility. Judges are patient here to prevent misunderstandings, which protects both the defendant and the integrity of the trial process. Think about it. Could you defend yourself against felony charges without formal training?
Your choice to represent yourself, you're making that on your own. Is that correct?
That's correct, Your Honor.
You understand the court can appoint an attorney to assist you?
Yes,
Yep.
is.
I know. Yeah, I know he's helping you,
Yes.
but you understand that he's not really representing you. Like, in other words, he's not doing the cross exam, direct exam.
That is correct.
All right, and you understand that while it might seem illogical, I have to, by law, require you to follow the same rules in the courtroom, okay? So if you need to enter a piece of evidence into, an exhibit into evidence, you're asking questions, you're gonna have to follow the same rules, okay? And just make sure you say yes.
Yes.
Thank
yes.
you. Every person has a right constitutionally to due process, and every person also has the right to represent themselves. And again, I also just needed to make sure today that you are making this choice to continue without counsel. In other words, representing yourself on your own. Is that right?
That is correct, yes.
And the key issue when I say on your own, no one's forcing you, no one's pressuring you. It's your choice.
They are not.
Okay, copy that.
May I?
Yes, sir.
It's my understanding, Your Honor, that there's a conflict of variance in the law. Equity should prevail. I'm prepared to wrap this up and settle all of this. It can be done here in this venue. That's exclusive Article 3.
Here, Thompson invokes terms like exclusive Article 3 jurisdiction and equity classic sovereign citizen rhetoric. For the audience, this is a perfect example of how internet legal theories enter real courtrooms. The judge doesn't dismiss or ridicule. Instead, he calmly steers the conversation back to verifiable facts and procedural law. This demonstrates courtroom control and patience. Key takeaway: arguments based on misapplied constitutional theory hold no legal weight. Courts respond to evidence and precedent, not online forums. For viewers, notice how the judge educates while maintaining authority, a model of professionalism under pressure.
And making sure I know when I've got to be here and what's going to trial. I don't get involved. And even now that we have a trial by jury, I'm not involved other than I'm telling that I run Tiger Stadium here. I mean, this courtroom, and this stadium will be available for the two parties. That's it. Okay. So I appreciate that might be your interest and that might be an objective. I can't make a ruling unless there was an appropriate motion. Now, in a criminal case, you can't file a motion to dismiss. I'm always surprised by how many attorneys, not these two gentlemen, would file a motion to dismiss in a criminal case. You can't do it. You can in a civil suit. That would be different. But here, we can't do that. The law does not allow me to resolve this case unless you were all doing a trial without a jury. Since you're doing a trial with a jury, all I'm in charge of is monitoring Tiger Stadium. Okay?
Could you please repeat yourself the last two sentences, because I heard something and I want to make sure I heard it correctly.
Hopefully I got it right. You can't do a motion to dismiss. Well, you can in the middle of the trial when the prosecutor rests. If the prosecutor doesn't prove each element, then you can do a motion for a directed verdict pursuant to Michigan Court Rule 6.429. That's 429 or 419. I think it's 429. You can do a motion for a directed verdict at that time. Until we get there, I can't dismiss a charge. There's some other rules, like if he violates the 180-day speedy trial clock, right, and you're sitting in trial in jail. But other than that, there aren't any ways that I can dismiss the case unless this case is before me, there's no jury, and it's in a trial. So if you requested and waived your right to a trial, by the way, Mr. Denhouten would have to waive his right to a trial, and I would have to agree. Since you both have told me you want a jury trial, or at the very least, Mr. Denhouten has, I can't decide the case. Okay, that's all.
That's
okay. It's all right. That's what I'm here for.
I do appreciate you bring up the Constitution. Mrs. Madison, any law that Congress or any legislature passes, if it violates the Constitution, it's null and void on its face. I'm not here to argue. I'm just making you aware of what's happening.
It's been a long time since I had that class, which was common law, where we had to deal with Marbury versus Madison. I'm aware of it, but as of right now, there's nothing to address. So bond continues. We'll see you on the 19th on circuit court here in Missaukee County. Our first case this morning is People versus David Thompson. This is file number 25-1379-FH. Mr. Thompson, you can come and take a seat. I don't know which attorney's handling it. So
We are David Denhouten on behalf of the people.
court recognizes the defendant, Mr. David Glenn Thompson, who is now at the defense table, and he is currently representing himself in this file. Mr. Thompson, as you might recall, I just need to go over a few things the law requires me every time. Do you understand that you have the right to hire your own attorney?
That is correct.
And you understand that you have the right to have the court appoint an attorney to assist you if you cannot otherwise afford it?
That is correct.
And you also have the right to self-represent pursuant to the Constitution. You understand?
That is correct.
And you are electing to represent yourself. Is that correct, sir?
I am, Your Honor. Yes.
And I think you've represented yourself in this file the entire time.
Yes.
And through district court. Okay. All right. So we're here today for two things. The first is we're here today for a pretrial conference. The pretrial hearing today is just to find out where the case is going. The case probably, yes, just recently bound over to the circuit court after going through the preliminary exam phase in the district court. And I see that the felony information was filed on February 6th. And the court then subsequently issued, assume I did. Yes, a scheduling order. Or about, actually, that was done on February 5th. No, it looks like the information was dated February 5th, but filed on the 6th. We're here again today for a pretrial conference hearing. Mr. Thompson, the only thing we do at a pretrial conference hearing is just to find out where the case is going. If there is a resolution of any kind, you guys can tell me. If not, then I'm going to ask if there are some other, I'm going to ask a couple other questions. The first thing here is see that the defendant is pending charges, and I didn't say what they were. Looks like there are 2 counts for a possession of a controlled substance. All right, Mr. Thompson, is there any resolution between this case, I'm sorry, in this case, as far as you know?
Your Honor, I believe there is.
Okay, well, hold on. I just got to ask the other party first, because a resolution means an agreement. Mr. Denhoughton, are you aware of any pretrial agreement?
I'm aware of that.
All right, thank you. That just lets me know that I've checked off that blank. What do you think is the nature of the resolution then?
Your Honor, I made a deposit with an ex parte hearing regarding another matter, equity taking jurisdiction to avoid a multiplicity of suits, putting up consideration for full accord.
This is the moment where Thompson's fantasy law collides with real jurisprudence. Terms like conflict of variance and equity shall prevail sound impressive but have no legal effect here. The judge remains composed, demonstrating how courts handle pseudo-legal tactics without derailing proceedings. For viewers, this is educational. Understanding the difference between legitimate legal arguments and ideology-based claims is crucial. Courts rely on statutes, evidence, and precedent. This is also a chance to engage the audience. Have you ever encountered someone trying to use internet legal loopholes in real life? Share your thoughts below.
That would be another one of those envelopes that you.
Yeah. I understand. Okay.
If there's any other instructions or my duty that I'm aware of, but I'm willing to correct my mistakes.
Okay. Let's take a quick look here. And you were giving me a reference to the Judicature Act, and I know it's 600, and you referenced the
576, Your Honor.
Okay. And how do you think deposit? What did specifically again? Did you deposit
A certificate of security?
Okay. And so, what security was it that you tendered?
That was consideration
Or
any outstanding liabilities, Your Honor.
okay. So your deposit of this certificate of security applies to how much was it for?
That it has been unassessed and unknown at this time, which is what I'm seeking further from the court assistance in.
All right. So, and you think that somehow takes care of this particular file?
Due to the fact that where there's a conflict and variation in the law between common law and equity, Your Honor, equity shall prevail, and equity takes multiple jurisdiction to avoid a multiplicity of suits.
All right. So, are you charged with
This VO highlights judicial transparency. The judge clarifies that guilt or innocence is determined by a jury, not the bench. For viewers, this is key. Jury trials protect impartiality and due process. Sovereign citizen arguments often misinterpret or ignore this, thinking they can bypass the system. Here, the court reiterates that the process itself is the law's safeguard. Engaging the audience. Consider why juries exist. Could you fairly adjudicate complex cases without 12 impartial jurors? This insight reinforces that procedural fairness is as critical as the legal rules themselves.
Solution to the case. Filing whatever you think you filed doesn't resolve this particular case.
I understand, Your Honor.
Okay.
In equity, I thought that they took jurisdiction to avoid multiplicity of suits. So
No, multiplicity is something different. Multiplicity is generally used if you've been charged with the same act more than once, or if you've been tried more than once, then that becomes double jeopardy. Multiplicity is something entirely different. Unless you're telling me you've been convicted of the same offense already before, which I know the answer is no.
I have not.
It's okay. So, I'm sorry, sir, I cut you off.
I do have evidence that I did deposit with the prosecutor's office of potential resolution.
Okay, so you made an offer to the prosecutor to resolve the case?
Yes, Your Honor, and I've got the
Okay.
card receipt.
That's okay. And so what happens here is I'm just the manager of this small version of Tiger Stadium. And I always use Tiger Stadium. By the way, I don't even watch baseball. But anyways, this is my little Tiger Stadium. All I need to know is that somewhere in the future, and the date is currently on a piece of paper, looks like that is May 8th, May 6th. May 6th, we've got a game. It is the Tigers. That's his home stadium, so we'll say that's Mr. Denhound versus the Twins. That's Mr. By the way, I like Minnesota, that's fine. But all I need to know is, are we playing baseball on May 6th? If the answer is either yes or no, we're going to get 2 bites of that apple. Today's the first one. The second one comes at the final pretrial conference. So today, do I keep the game currently scheduled, People versus Thompson, set for May 6th? That is all I'm here to do. Now, if you and Mr. Thompson or Mr. Denhound reach an agreement, that's between you guys. I don't care what you guys deal with right outside. There's nothing to do with me. Mr. Denhound says they don't have an agreement, which means your offer has been, at least at this.
Thompson attempts to use an equity deposit to erase legal liabilities. This is a classic sovereign citizen maneuver, filing paperwork or financial instruments to claim debt cancellation or case resolution. The judge, as expected, asks for proof and explains real law operates on verifiable evidence, not abstract claims. For viewers, this demonstrates the limits of legal theatrics. Filing documents alone cannot satisfy criminal charges or civil obligations. Key lesson: in court, substance always outweighs form. Share your opinion below. Have you ever seen attempts to settle legal issues with unconventional paperwork tricks?
The discovery in the case, like the police report, any
I'm not
body.
sure.
Yeah,
Sorry
it's
to
okay.
interrupt
It's
you.
okay.
I'm not sure that I have it in total.
All right. So the best thing you can do is you can look at the police report, and if, for instance, it says, well, hold on. Have you received a copy of the police report?
I believe I do have one, Your Honor.
Have you received, should be a lab report from the Department of State Police, the Forensic Crime Lab?
I'm not sure if I've got that yet.
Mr. Denham, has there been a crime lab report yet? Sometimes they're running behind. Nothing works like it does on television.
Your Honor, it has been submitted, but I don't believe we have a copy of it.
All right, so that means I turn over here, and I'm just going to say on my discovery issue, still,
Your Honor, I stand corrected. I do have a copy.
never mind. I don't have to write that down. The next is was there a prelim?
There was, Your Honor.
Okay, let's make sure that I ordered the prelim transcript.
There is audio and video that has been submitted as well.
Okay.
He doesn't have a copy. I'm happy to send another copy.
All right, so I see that the transcript has been ordered by my office. The transcript of the prelim will be prepared and issued to both the prosecutor and to the defendant. Now, the next question would be, I'm sorry, if you have received those. You say you think you have, so I'm just going to tell you what you can do is look at the police report. And typically on the last page or two, it will report whatever exhibits they may have collected. let's say, for example, this was well, I don't use an example, let's just use the charges. If there was some kind of baggie, that will be put into evidence. That'll be listed on there. You'll get the baggie. You'll get the test of that baggie. Now, you should also be able to get the chain of custody, which should generally come. So you just want to make sure that there's the chain of custody. Now, if the defense chooses ever to have a substance retested, it can ask for that, but it pays for it you would pay for it on your own. You'd have to find a lab, and then you'd have to come and have me give an order that says, hey.
This moment illustrates another legal safeguard, the speedy trial rule. Even when defendants self-represent, the court ensures their constitutional rights are protected, including time limits for bringing a case to trial. Thompson's focus on unrelated arguments contrasts sharply with this core principle. For the audience, understanding procedural rules like the 180-day rule is vital. They prevent indefinite delays and protect defendants. This is another teaching moment. Courts enforce rules regardless of personal belief or misunderstanding, reinforcing that procedural law is not optional.
Schedule order, I said, if you have any motion, such as a motion to suppress, you can raise it within 30 days of the transcript. So if the transcript gets provided to you, and let's just say for a random choice, March 15th, you have until April 15th to raise a motion, like a motion to suppress. Okay. Now that I've covered all that, now let's turn to this last question here. The next question here is, Mr. Thompson, looks like on February 19th, the prosecutor filed a petition asking to show cause. Now, basically alleging that there was some kind of bond violation. Particularly in this instance, the bond violation is that you allegedly failed to appear for a drug test on February 9th of 2025, and then February 16th, 2025. Now, the prosecutor could have asked for a bench warrant. He didn't do so, which is pretty common in this kind of a situation. I can tell you that either party or the court can ask to review someone's bond, and there isn't a right to a trial. There is no jury. There's no proof beyond a reasonable doubt. It's just that the court looks at it and gets to determine whether or not that's a violation. And then, if so, what should I do? Should I revoke bond? Should I remand the defendant into custody? Should I modify the bond? Or should I just wag my finger if they don't do that again? Now, do we want to have a hearing on that? Do you want to have a hearing? And by the way, well, hold on. Miss Dean Stark joins us today, also via Zoom from the Wexford Misaki Community Corrections Program. Miss Stark, are you here for this one?
Yes.
I just want to ask you this question. Have there been any other alleged violations?
Boom. This is where the court lays down the principle of automatic legal obligations. Whether you agree or not, certain laws and statutes kick in when you engage with society, driving, using public roads, or benefiting from public services. Thompson's argument that I don't consent is a common sovereign citizen thread, but it doesn't hold up legally. For the audience, take note. Consent is not required for laws to apply. This is a teaching moment for anyone interested in constitutional theory versus practical law.
Two violations on the 9th and the 16th for no shows.
All right, but nothing since then?
No.
All right, thank you. All right. Has he shown up at all for any testing?
He has.
All right. Any I assume they've all been negative?
Just positive for THC.
All right, and that probably wasn't listed. Okay, all right. And by the way, Mr. Thompson, if you admit to failing to show up for those two tests, I'm just going to go with the finger wag. And say, don't do that again. Make sure you show up. Okay. Is it true you failed to appear for those two tests?
By mistake, I did, Your Honor.
To wrap up, Thompson's sovereign citizen strategies failed at every turn because law relies on evidence, not ideology. The judge maintained integrity, explained rights, clarified rules, and ensured procedural fairness throughout. For viewers, the key takeaway is simple: understanding the law, following procedure, and respecting court authority are essential. And here's your call to action. If this case fascinated you, hit that like button, share your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns and real legal lessons that will challenge your perspective.